and welcome to Represent NYC on Manhattan Neighborhood Network, and thank you for joining us. I am Assemblymember Dan Quart, representing Manhattan's 73rd Assembly District. My guests today are Rashida Richardson, Legislative Counsel for the New York Civil Liberties Union, and William Gibney, Director of the Legal Aid Society's Criminal Practice Special Litigation Unit. Today we will be discussing criminal justice matters, police reform and civil liberties, and the intertwining of those things for public policy in New York City and beyond. The first thing I wanted to talk about and get both of your opinion on is body camera. New York City Police is going to increase its purchase of body cam footage, dashboard cam footage over the coming years, and that increased purchase has serious public policy ramifications for not only the New York City Police Department, but the entire city of New York and how policing is done in different communities. I wanted to talk first, ask you, Bill Gibney, with respect to the Legal Aid Society, how will the increase in purchase and use of body cam footage by New York City Police Department officers and people in the field affect criminal defendants in the real world as they step foot in a courtroom?
I think it's going to depend on how the cameras are deployed. You know, the cameras can be a very good thing. They can also be a very destructive thing. So I think it's important for the new leadership in the NYPD to identify the goals about what they want to accomplish with the body camera project. It's a good time to be asking the question because a purchase order just went out for many more cameras, and not only New York City but all of New York State is going to have to wrestle with this issue of what are the goals that we're using for the body camera program. So I think that the important goal should be to increase the trust of the community, improve the relationship with the community, and to help improve the interaction between the NYPD and the citizens of the city of New York. If you keep those two goals as the primary purpose of the program, then a number of things follow. You don't want to keep the camera footage secret all the time. You want to have the ability to share that camera footage with the community. You want to set up rules that establish certain privacy expectations. So, you know, if it's a raid on a home, you want to have the ability to not disclose everything that's going on in that home.
It's interesting you bring that up, the dual concerns of greater trust between police officers and the community, but also privacy concerns. Right. It's actually the subject of legislation that I'm sponsoring to try and accomplish those two very important goals. But talking about privacy, Rashida, from the Civil Liberties Union perspective in body cam footage, there are some real privacy concerns that we don't want police officers' identity made public in an unfair way, Gawker-type websites and things of that nature. Is there a practical middle ground or solution where we can have greater disclosure of body cam footage as it becomes more prevalent throughout the NYPD, but still protect legitimate privacy concerns of officers and people who ought not to be disclosed in a public way?
Yes, I think Bill was starting to touch on some of these issues. There are privacy concerns both on the use of body cameras in the public sphere, but also sometimes in the private sphere, because there are recordings happening in very sensitive areas such as hospitals, homes, and even bathrooms. And there's also recordings taking place of very sensitive interactions, like an interview with a sexual assault victim or domestic violence situations. And just the presence of cameras can have a coercive effect in those situations. So I think one of the checks that you can have to sort of safeguard these privacy concerns is to make sure that there's notice requirements around so people know that they are being recorded, and there's opportunities to take away that consent for recording, especially if it is a raid on the home or in some of these sensitive areas that I mentioned. And then I think there's also concerns for both the officers in the public sphere, because just like body cameras can be an opportunity for police accountability, they can also be an opportunity for mass surveillance. So there also needs to be limitations about when body cameras are used and officers' access to that information. So officers shouldn't necessarily be allowed to edit before the footage is received in any area or deleted in any way, and there should be proper retention policies, because that's one of the major concerns that is constantly raised, is that we're collecting all this footage and where are we going to store it and how long are we going to store it, but we also want to make sure that it's not being deleted at a fast pace where possible exculpatory evidence can be deleted or other evidence that may be useful to individuals.
It's interesting you say that. Commissioner Bratton made that very complaint to me about where to warehouse all the footage that he expects to be taken by his officers or Commissioner O'Neill's officers over the coming months and years. But have other jurisdictions been able to come to a fair compromise in terms of increasing body cam footage, warehousing it, making it available to the public in a reasonable way, and also protecting privacy concerns?
I think a lot of jurisdictions are struggling with this issue in the same way that we are in New York, because there are very serious concerns on both ends, and how to balance them it's a very sort of tough balance to strike. So I know in some jurisdictions, I think in Seattle, they were making footage available to the public, but that can kind of become unwieldy at a certain point, because one, how long do you store that information? Are there sort of procedures that you have to ensure public access, but sort of securing people's privacy? So it's difficult, and I think a lot of jurisdictions are sort of struggling in the same way that we are with what is the right balance.
An important issue is who controls the data that gets collected. You know, we saw in Chicago, there were a series of videos about a police shooting that never became known and are known to the public for over a year after the events occurred, right? And that's an example where the decision was made for the police department to control the footage and then ultimately decide what they want to release, what's in their interest to release. And that's an example of where, you know, there was an opportunity to improve relations with the community by sharing the data, and they opted not to do that. So who controls the footage is
for very poor. Exactly. I mean, in Chicago, it seems like an example of what ought not to be done, and the after effects and ramifications are damaging relationships or relations between the police force and the individuals who they are policing.
That's right. That's right.
I wanted to turn to a topic, stop and frisk, and racial bias in policing, and it is timely because of the taping of this show. Commissioner Bratton's last day as commissioner. Commissioner O'Neill takes over, and Commissioner Bratton, he wrote an op-ed this morning, and he talked about some of his experience as a young police officer in Boston and his colleagues, and what he liked about some of his colleagues and what he was critical also. And I wanted to read to you a quote that I found significant from Commissioner Bratton's op-ed. And he said, "You have to reach out to the idealist," he's talking about police officers, "who live in the heart of many a cynical cop." Those are Commissioner Bratton's words about his real-life experiences. And that we have the end of stop and frisk. We have a federal monitor ensuring that result. And we have all sorts of programs about training about implicit bias and otherwise in the NYPD. My questions for both of you are those programs working? If they are, explain how. If they're not, please tell our audience that as well. And if there's more to be done, what should we be doing? That's for both of you, so whoever would like to start.
I'll start. I think it's too early to tell, and I think what happens in the future will help set Bratton's legacy with the NYPD, largely as a result of litigation that was done by the Legal Aid Society and the NYCLU and other organizations where the issue of stop and frisk was litigated really bitterly over a long period of time, and the NYPD really dug in its heels about change. In the last couple of years, under the new administration, we have seen settlement of those lawsuits and a monitoring and negotiation process with the NYPD about changing some of the rules. So Commissioner Bratton mentioned some of the changes that have occurred within the NYPD, I think largely as a result of that process. And I think there are some useful steps that have been agreed upon, de-escalation procedures so that an officer doesn't resort to force as a first response to a problematic situation. Better training there is a good example of that. But as Bratton mentions in the article today, there's a big difference between setting rules and changing the culture of the NYPD. So I think we're at the stage of rules are being changed, but we haven't changed the culture. And that's the next step, and that's a more difficult step to take, I think.
I would imagine whether in Albany, legislators working through legislative remedies, or at the city council level with either legislation or oversight, there's important work being done. But to Bill's point, the solution may not be completely legislative or even oversight. Some of it has to be internally by the NYPD with the change of culture. Can you speak to that point, Rashida?
I definitely agree in that there needs to be some form of cultural change, and I even know in participating in community conversations around this, one thing that even a family member of mine mentioned is that years ago, a lot of the police who would police neighborhoods were from those communities, so there wasn't such a disconnect with those who they're policing, and that's not so much the case today. So I think there's a certain level of cultural competency that needs to take place, but also just a different view on how we're policing and who are the communities that police are policing in. So that way it's not such a them versus us sort of scenario, but more we're all part of this community and making steps to make it better.
I think you really, if you've read it, I'm sure both of you have read portions of it, the Department of Justice's investigation, review, and report on the Baltimore Police Department really set forth a picture of a us versus them community policing, which in Baltimore, obviously a different jurisdiction than New York City, to disastrous effects. What type of programs, training? I know Commissioner Bratton talked a little bit about his community policing policies that have been implemented, but what more can be done, should be done to break down those walls of an us versus them mentality that so obviously by the Department of Justice caused such grave problems in the jurisdiction in Baltimore?
I think it can be twofold. So I think doing some of the programs like the one you just mentioned can be helpful, but there's also work I think that can be done on the police union side, because if there's certain stressors, I guess, to officers about their employment, then you're not going to have this sort of community sense in the work that you do, but more I need to hit these quotas or do certain jobs that is necessary for me to maintain my employment. So I think in addition to making sure that there is more of a sense of community amongst the officers in the communities they police, and we also have to think about the employment practices or even management practices that may sort of cause the schism between the community and police.
And talking about numbers of arrests in terms of the quality of policing is something Bill and I are familiar in a piece of legislation that I sponsored and passed working with the Legal Aid Society on dealing with folding knives and trying to change the penal code with respect to that aspect. Not getting into the particulars of that bill, that legislation bill, but to Rashida's point in terms of changing the interaction between police officers and the communities in which they police, what do you see as practical solutions to that issue?
I think the folding knife issue is a good example of a situation that plays out large in communities. What we saw in the folding knife issue is workers getting arrested for possessing a tool that they use on their jobs to cut sheetrock or curtains or and various other construction projects. People were arrested time after time after time for possessing this knife that they use as a part of their, sometimes the jobs gave them out, certain training programs were giving out the knives. But what we saw is that 86% of the people who were arrested were Black and Latino. And you know that vast numbers of white workers were using those exact same tools. But it's an example of how we seek to use our police forces, where we target our police forces, largely in neighborhoods of color. And that plays out on issue, it's played out in the drug law debate, and in a series of other criminal justice issues, how we deploy the police forces, where we seek to target them, and who we arrest, and then who do we choose to prosecute once the arrests are made. You know, there's discretion in the prosecutor's offices. Are we going to go forward with this charge or not? And to a large degree, we see the original bias policing that makes the arrest just continue through the prosecution process. So.
I wanted to turn to something that's been in the news lately. And that's the issue of subpoenas and seeking information from Apple and other phone providers. I was at a ABNY breakfast, that's the Association for Better New York, and it was a presentation about counterterrorism and the NYPD's efforts. And the NYPD has a significant, I guess you would call it, counterterrorism unit or unit committed not simply to policing and communities. And I think one of the issues that came up was the ability to secure information, raw data, records from different phone providers, and the NYPD's efforts to that in support of their as they set forth, in support of their counterterrorism units, the use of the Manhattan District Attorney's Office or other district attorneys' offices throughout New York City to do that. So this issue is timely, and it's also one that brings both the need for law enforcement to secure information versus the legitimate privacy concerns, not just of phone carriers and providers, but the thousands of people who walk around with cell phones each and every day. So, Rashida, what are the problems, what are the solutions, and how do you see this issue going forward in the future?
So one of the major problems that we're seeing with law enforcement access to electronic communications is that in the majority of cases, law enforcement is not using a warrant, even though in a lot of, I think, public statements and even on TV, it's like, we can't get access to this information even when we have a warrant. The true facts is that warrants aren't being used in most cases. And unfortunately, this is because New York's laws don't have many privacy protections, but also law enforcement are using loopholes in antiquated federal laws that allow for them to get access without a warrant.
Just on that point, because I think people, to the extent they know about this issue, they think it's a warrant versus not a warrant. So if you can explain how this information is secured without a warrant, I think that would be helpful.
Yeah, so I guess I'll take a step back and explain how we sort of know what's going on. A lot of the providers like AT&T, Verizon, Facebook, Google are releasing transparency reports now on an annual or biannual basis about these government requests. And I looked at Verizon's report from earlier this year, and they received over 135 requests for customer data, and warrants were only used in 11% of those cases. What law enforcement is using in a lot of the other cases are subpoenas or lower court orders that don't really rise to the same level of discretion that would be necessary for a warrant. So it's simply, we need this information because we're doing an investigation and no explanation.
So an information subpoena is served upon a carrier? And does obviously the subpoena would likely be towards an individual, not simply for records en masse. Is that individual ever placed on notice that his or her records are being sought?
No, so unfortunately, I mentioned the antiquated federal laws. One of the major problems with the federal laws and what often happens in these cases is law enforcement will ask for information, and there's a gag clause attached to the subpoena or court order that they use. So the provider, let's say Verizon in that case, cannot tell the customer that their data was requested. And on face value, I think some people would just be like, I'm not doing anything wrong. I don't see an issue with my customer data being requested by the government. But that data can reveal a lot of information. So just your phone records not only reveals who you're calling, who you're texting, but also who's contacting you. And it can also reveal, to a certain degree, your location information, because cell phones are constantly connecting with local cell towers. So that information can sort of be narrowed in to say, we're in the studio at this time.
Are states, under federal law, are states permitted to pass legislation that would provide individuals greater notice, greater protections than currently exists under federal law?
Yes, so there is a provision in the federal laws that allows for states to have narrower laws that are passed, so that way notice can be provided. Another big piece is that the warrants should be required, but the warrants are required to have a certain level of specificity, so you just can't ask for all of a customer's data for all of time, but it needs to be narrowed. And there was a law passed in California 2 years ago called the California Electronic Communications Privacy Act that does provide those protections. And we're currently working with you and other legislators in New York to get a similar law passed in this state so that we can make sure New Yorkers have those same protections.
New York at present doesn't have those protections for individuals through their carriers. So so right now it's just the carriers on notice of these subpoenas.
Yeah, and unfortunately, the other piece, in addition to the carriers not being able to tell the consumer that their data is being requested, they also don't have standing to contest those requests. So if you look at these transparency reports that providers are issuing, they'll also show the percentage of times that the information was provided. And a lot of the times you'll see that it's in the high 90s and 80s range that information is provided, or the full amount of information that was requested was provided.
Just one other question. It's difficult to, I imagine this is a difficult endeavor to work on a 50-state-by-state basis to pass legislation. Are there efforts in the Congress to remedy this as a federal matter, thus not requiring action in 49 other states, similar to what California has done?
There has been some activity on the federal level. This past year, there was the Email Privacy Act that was introduced, but unfortunately, it went nowhere, and it wasn't as expansive in its protections as CalECPA or the bill that we're working on in this state. So it didn't protect location data, which is very important because just seeing where someone goes throughout the day reveals a lot of information, and it didn't have a lot of the same remedies or requirements that the state bills do.
I guess it's fair to say we'll have to wait to the results of November 8th to see if there's a better likelihood of success next year in Congress on this matter.
Yeah, we can hope.
Bill, I know you wanted to talk a little bit about this issue and with respect to, in effect, in New York City, and something many people in New York I didn't know till you told me about this issue and its practical effect in New York. So.
Yeah, there's a range of concerns, privacy concerns about emerging technologies. And one of them I think is really worth the public becoming aware of is the VIPER program, where the police have a technology that allows them to, in effect, set up a fake cell phone tower. As you know, communications are delivered by cell phone towers, and it's possible to identify where people are through triangulating the nearest cell phones. What the police do with this is they set up their own fake cell phone tower, and all of the cell phones in the entire neighborhood report to that cell phone tower. So the police are able to gather information as to the identity and location of everyone in the neighborhood. And a particularly disturbing part of this is that we've learned now that this technology has been used for some number of years by the NYPD, but we have not seen cases where criminal defendants are prosecuted, and the VIPER program has been identified as the cause of the identification of a certain defendant.
Has the City Council ever conducted any oversight hearings of the NYPD specific to the VIPER program that you're aware of?
Not that I'm aware. Yeah,
so unfortunately, the more, I think, manufacturing term for this is stingrays,
Yes.
and a lot of these technologies can go through loopholes of the City Council process. So they may be purchased by the police foundation, or it may be given for free through the federal government. So there's a lot of small loopholes from the city procurement process that this technology and a lot of other surveillance technologies just sort of slip through. So what we think should be under proper oversight is just not happening, and then we don't know how they're being used.
And do we know where this data, raw data information is stored?
No, we know very little about this program, and the police seem to be concerned about actually litigating it. So they claim it's a perfectly legal program, but by never identifying when it's used, it's impossible to litigate it in a criminal case.
And just to piggyback off of something you said earlier, we also don't know what models they have, and different models of this technology has different capabilities. And there's major concerns about where this technology is being deployed, because some versions of this technology can interfere with service. So if this technology is being used in predominantly poor communities of color, who may be more reliant on their cell phones for internet access or just using it to call people, if there's interference with that service, that can cause major problems for the people in those communities where this technology is being used.
It certainly seems like an area that's crying out for oversight, and something I'm sure both in the legislature and the city council will be brought up with Commissioner O'Neill in the future. We only have a couple minutes left. I just wanted to raise one more issue and get both of your points of view on this. In Albany, legislatively, raise the age has been a significant issue. Many of us in the legislature have deep problems with the continued prosecution of 16 and 17-year-olds as an adult. Speaking for myself, I think it's a poor public policy, and have said so publicly, but it has not been changed at the state level. If both of you can describe your feelings about this issue, and what do you see forward for the future, and what should be the resolution on this issue?
I agree. I think it's a poor public policy in that we shouldn't be charging children as adults. It's tons of research that shows that young people's brains aren't fully developed until I think they're 25. And therefore they're not able to understand the consequences of their actions, whether criminal or not. Very young people aren't even able to comprehend the judicial proceedings, but New York's one of the states that does prosecute 7-year-olds, which is very problematic. So I think we do need to raise the age, but we can also look at states that have made those reforms, more recently Connecticut, and there have been major financial and social benefits that have occurred from making the proper reforms.
And Bill, I just, as a legal aid society attorney, as a person who stood in a courtroom defending a 16 or 17-year-old, tell us from a practical perspective, what's that like, how difficult it is, and I think the listeners would gain a benefit from understanding that in a practical sense.
New York should be ashamed of itself. I mean, instead of being the leading state to recognize that 16-year-olds should not be prosecuted as adults, that they don't understand in the courtroom what's going on around them, that the science shows that they are not to be held, they have not formed the judgment that's capable of fully deciding right from wrong. We're prosecuting them as adults. We're sending them to Rikers Island, of all places, to 16-year-old children going to Rikers Island as adults. We are punishing them as adults, and we're branding them for the rest of their lives with criminal records instead of sealed family court records. So it's just it's an atrocious process then.
Well, I wish we had more time, but we're out of time for today. To be continued in the future, I hope. I would like to thank Rashida and William for joining me on today's program. I'm Assemblymember Dan Quart, and thank you for joining me on this edition of Represent NYC on Manhattan Neighborhood Network. Goodbye.